Sakas refused the importunation and declined the bribe. And he decided according to his conscience. But the two justices who accepted the bribe ruled in favor of the man who had not contested the election, Ugochukwu Ubah. The man who did not collect the bribe ruled against Ugochukwu Ubah. So Ugochukwu Ubah won on a majority 2-1 vote of the Justice of Appeal, went on to serve a term in the Senate. That was where this began, because it became evident that you could become a winner of an election in which you are not a candidate if the judges said so. And the man who then made that the modus operandi for electoral victory in Nigeria was a man called Obanese Alphonse Ibeke. Obanese went to the parliament, to the National Assembly 3 times without ever having won an election. And on 2 occasions, he didn't even run. In 2003, he won after 2.5 years in court. In 2010, he went to the Senate and toppled Joy Emodi after Senator Emodi had been in Senate for 3 years plus. And in 2011, he got a High Court judge to give him an injunction, sending him again to the Senate. And because that was so corrupt, it was so evident, the Attorney General at the point then prosecuted him for fraud. Now, but by then, this modus operandi had left these two guys and had become federalized. And to such a scale, it is no longer possible to control. But this is really the origin of the species.
And, the chapter on Obanes could be a Nollywood movie any day. And, the chapter on Obanes could be a Nollywood movie any day. I mean, I totally enjoyed reading it, although it was really painful to see where we've gotten to. But what is it about our history or our traditions, our culture, that has made this really terrible system stick with us? And maybe also in addressing this, maybe you can touch on another issue that you really dealt on in the book, which is where the judges have started appointing their sons and daughters and family members to judgeships in Nigeria, further entrenching this challenge that we have.
Having trained as a lawyer, I want to say something that a lot of lawyers may not find very happy, but I think may not be very happy with. But the thing that has entrenched this, in my view, is the teaching of law, the way we teach law. We teach law as doctrine. And you see, learning by the road. When you repeat doctrine and repeat doctrine and repeat doctrine, you program people against curiosity and against intellectual honesty, against facts and against evidence. Okay? So, first of all, we have programmed people in 2 ways. Number 1, we program law graduates to believe that judges are a superior breed. They can do no wrong. My law, don't watch it. And, all that obsequiousness then precludes people from looking at the evidence of corruption before them. The evidence of things that should not happen. So we do not actually challenge things that we know. Instead, because those things are too disconcerting, we are more comfortable with simply spouting the things that judges say. Okay, no matter how bad those things are, and no matter how unreasonable. So if you take the case of the Uba brothers, the Ugochukwu Ubah and Nicholas Ukachukwu case, after that judgment sending Ugochukwu Ubah to the Senate, there was a complaint to the National Judicial Council. The National Judicial Council investigated, found as a fact that the judgment had been procured by corruption. They recommended the dismissal of the 2 justices of appeal who collected bribes. They were in fact dismissed for judicial corruption. Then the people affected by that corruption appealed. The Court of Appeal said, we have decided the case, we cannot reopen it. But that is stupid. That is clearly stupid. I'm sorry, there's no other way to put it. if a judgment has been procured by manifest fraud, affirmed by the National Judicial Council, how is it a judgment? But lawyers are encouraged to cite this and say it is precedent. It cannot be precedent. And if you say anything about it, they say you don't respect judges. And so we are taught not to be curious citizens. And that becomes the standard. So legal pedagogy is problematic. And this begins from the origin. You start with legal system, administrative law, constitutional law. You're taught that judges are gods.
Infallible.
That notion then undermines imagination. And really, I for anybody who is a law teacher here, I do think there's such a crisis with our pedagogy of law that everything needs to be torn down and rebuilt. And that, for me, really is why, as a law teacher, I no longer teach doctrine. I teach law as narration, as historical narration. So when you unbundle the actors and just follow the story, you will discover things that will shock you. So I'll give you an example. That most lawyers in Nigeria know of a case called Mojeku and Mojeku, which comes from Newi, of a widow whom the Court of Appeal liberated in 1997 with jurisprudence that appears fantastic, that says a woman is entitled to inherit the late husband's estate. Yes, and it's done in such flowery language by Justice Nikki Toby, God bless his soul. Everybody cites it. But you see, most of the law professors will teach this, and what they will not teach you is that woman's husband died in 1963. She started litigating in 1966, and she got judgment in 1997. Add the years. What does it give you? It gives you 34 years of widowhood or 31 years of litigation. So you ask yourself the question, who wants to litigate for 31 years in order to get fancy jurisprudence? How many widows will survive for 31 years? If you ask that question that way, you will no longer celebrate that decision. You see it as a crisis for the Nigerian legal system. And you can then challenge your students. How can we make sure that no widow has to stay in court for 31 years? You will no longer be adulatory about that jurisprudence. You will be developmental about the jurisprudence. It changes your optics. It changes your methodology. It challenges you as a development actor. It challenges you as an intellectual and strategic leader. But our law teachers will not do that. They would rather adulate about the decision and miss the opportunity to transform our possibilities. This is, for me, the first thing. We've got to change the way we teach our young people. We've got to recognize that the role of a teacher is to inspire, to reimagine society. And in that, we are failing ourselves. The second thing is to not accept the opportunity, the challenge of institution form. So we teach our students that we got independent institutions at independence. That was a lie. That is a lie from the pit of hell, because colonialism was founded on dependency. Colonialism did not know judicial independence, so it could not have bequeathed to you what it did not have. Why is this so serious? Because if you realize you don't have independent institutions, you will work hard to create that as a political objective. But because we've come out believing we had independent institutions when we did not, we have lost everything. And so part of the objective really of the book at its foundations is to challenge us to accept the political project of evolving independent
constructs.
In parliamentary systems, of course, this is unlikely to happen because of the nature of parliamentary constituency. Was recommended by the Federal Judicial Service Commission as the top candidate. Another guy, male, was the alternate. The list went to the National Judicial Council. By the time he left there, they flipped it around. The justice of the court, the woman who had been recommended had been thrown away, and the man who was an alternate was made the judge, the justice of the Supreme Court. No reasons were proffered. And that if that woman had gone ahead, she would have been in line to be Chief Justice of Nigeria, but she was eliminated. Now, there's a lot of willing and dealing that goes on at the National Judicial Council, and that is where the insider dealing takes place. Do you know why? Every appointee in the National Judicial Council is owned by the Chief Justice. Now, it is called, the acronym is NJC. for the National Judicial Council and CJN for the Chief Justice. And what is it? People have just moved around the deck chairs of letters. CJN is NJC, the same letters. And the CJN totally owns the NJC. The only person whom they pay notionally or whom the CJN does not appoint are the representatives, the 5 representatives of the Nigerian Bar Association. But now you see, when the Chief Justice, the last Chief Justice, did not like the president of the Nigerian Bar Association, that's Olumide.
Yes.
We threw him out.
Yes.
Yes, Olumide Akpata.
Yes.
And that tells you that the Chief Justice is totally in charge of the NJC. Now, however, the Judicial Service Commission is different, because the Judicial Service Commission includes the Chief Justice, the Attorney General, President of Court of Appeal, and a few other figures. But the composition is more dexterous. It's not easily manipulable. And my view is we should abolish the NJC and capacitate the Judicial Service Commission to do what the NJC does. With the contradictions in it, it is more likely to have controls. But as long as we have NJC and JSC functioning together, there will be confusion. If, however, both of them must function, can we have the Judicial Service Commission on top of the NJC rather than the other way around? Because that would mean that you have some oversight of abuses by the NJC. You see, the NJC was designed by the military under paternalistic circumstances. And of course, it just happened that they had 2 decent men to begin with to lead it. One was Mohammed Bello, God bless his soul. The second was Mohammed Lawal Owais. They came from a different time and different discipline. It was not designed with people like Oluyikayode Ariwola in mind. And Ariwola totally showed up why the NJC has passed its sell-by date. And I do think, therefore, that we could easily dispatch the NJC, return the JSC, or flip them around, or in addition, do something else, which is insist that the NJC is not chaired by the Chief Justice. So because at the moment, the Chief Justice chairs both the NJC and the JSC, the Judicial Service Commission. So the Chief Justice gets 2 bites at the cherry. And so one easy thing we could do is, okay, we keep those 2 institutions, but you know what? The Chief Justice chairs one, but does not chair the other. And the one that is not chaired by the Chief Justice is on top of the one that is chaired by the Chief Justice. What about? So there are, and these are very modest, conservative proposals. I'm not suggesting yet, I'm not going down the route of what Kenya did, which is total turnover of its entire corrupt judiciary in 2010. Or what South Africa did, which was a supersession of the existing judiciary with a new cadre. So they left the Supreme Court of Appeal in Bloemfontein and moved the Constitutional Court to Johannesburg with a totally new bench, and moved the office of the Chief Justice from the Supreme Court of Appeal in Bloemfontein to the Constitutional Court in Johannesburg. That totally altered the balance, therefore, and reformed the judiciary. I'm not even going there yet. I'm saying we can be conservative and yet reclaim some trust. And at the moment, we are not even willing to imagine that.
So when you say we, you're not thinking Chidi and Patrick. You know, who's the we here?
The country, Nigeria. That's why I start with the citizen.
Who in the country Nigeria is actually set up to do this, and who can do it? Is it the NBA? Is it the Nigerian Bar Association? Is it civil society? Who?
It's you and I, and the people here, from whatever the country is. You see, the NBA is already too invested. Lawyers in private practice, litigating cases before the kinds of judges who benefit from this cannot do it, because they will tell you, well, you you can do this thing because you no longer go to court in Nigeria. If you were to go to court, your clients will suffer this, that, and the other one. And so as a result, lawyers cannot explore this issue to the fullest. This issue requires some intellectual risk and some moral risk and political capital. And we need to build up the political capital in the argumentation of the case. We cannot continue this way. And you see, the interesting thing is the politicians are now coming to me and saying, oh, thank you, but you need to help us. How am I going to help you when you're the person with political power and who's losing elections? Look at Emeka Ihedioha. He wins an election. and get stuffed out by the votes of 6 judges, 6 justices of the Supreme Court, none of whom had a vote in Imo State. And now, you see, you go to an election, and what is the currency in elections? It is votes, isn't it? Mm-hmm. And the Supreme Court is telling you that Supreme Court, comprising justices of the Supreme Court who cannot even come out of their bedrooms to vote on election day, who have never gone to campaigns and will not listen to the soapbox, they are telling you that the votes of citizens, many of whom have to jump hoops and survive attacks on themselves to vote, the votes of citizens are wasted votes. Zamfara State, wasted votes. Imo State, wasted votes. Bayelsa State, wasted votes. And so we are installing people on the basis of judicial pronouncements whom the people roundly rejected. In Zamfara State, Matawale lost in every ward and became governor because Supreme Court decided that the votes that beat him were wasted. And lawyers will come and tell you this is Supreme Court, it is final. It cannot be final in a democracy. This is the problem.
How not, Chidi? How is it not final if we've been thought that you know the Supreme Court position is indeed final? You know, what else can we do as citizens? What can we do as associations, as groups to ensure that it's not final? Because in our minds, all we know is that once the Supreme Court rules, that's it. You go back and you wait for another 4 years. What in concrete terms can people listening, people who are going to watch this later, do? How do we organize in a place where civil society organizations, in some cases, are extensions of the government itself, where the people are so poor that they can't think straight, where the people are so poor that they can't really protest? Where then lies the hope? How do we organize?
Patrick, I'm sure you're not a big man. I mean, you're physically imposing, right? But I don't think you have $2 billion in the bank or $2 million in the bank.
I'm still praying. We're still doing the fasting and prayer. Mm-hmm.
So this thing about the question is, do we want to suffer intergenerational poverty, or do we want to give our next generation a chance? Because then if we do, we've got to take a risk. We can't be making love and producing children just who are going to become slaves.